Right, good morning, everyone. Let's go ahead and get started. I'm waiting for, is anyone at courtroom two? All
Yes.
right, thank you. Good morning. This is the state all purpose calendar in the state court of Fulton County, Georgia. I'm Judge Melanie Williams. Today is July 7th of 2026. At this calendar, we will address matters for those individuals currently incarcerated, including arraigning cases, setting bonds, and taking pleas as necessary. All defendants, please be advised you have certain rights today, including the absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to counsel today. And as you can see, I'm conducting this hearing by video. I'm not there in person with you. That means any member of the public can log on and watch this. When I ask if you understand your rights, this is what I am referring to. Are there announcements before we begin from any of the defense attorneys?
Judge, if I may, position number 30 is going to be reset. I had requested a Spanish interpreter, but we don't need him or her. It appears that Martinez Perez has additional charges and the state had asked for a reset. So I just want to let the court know we do not need a Spanish interpreter today.
Okay, Miss Lewis, are you on the line? Oh, I'm sorry, Miss Grace and Miss Champion. Will you please let the interpreter know she will not be needed today? Thank you for that, Mr. Haddad.
Thank you, Judge.
So I'm sorry, Mr. Haddad. When you say reset, are we waiving? Or are we just
No,
gonna
Judge,
reset?
I think Ms. Evans' battle. It appears that they're requesting a reset for next week. I was unaware that the client has additional charges, other cases. So
Okay.
we're trying to
So
combine.
we'll reset 1 week next week. Is it full, Miss Champion, or can she go to he go to next week?
And Judge, to be honest,
Oh, she.
she's got an ice hold, so if it needs to be reset for a couple weeks, that's fine too, Judge.
Okay.
Whatever works for the
Okay.
court.
What's our? Can we send her out 2 weeks?
We can reset her to 7/14, Judge, if you want.
Okay. We'll put her 7/14 just to make sure that she doesn't get lost. All right.
Thank you, Judge.
Thank you. Are there any other announcements before we begin?
I'm sorry, Judge, do we have the case numbers for the additional cases?
Are they felony cases or they are
It's misdemeanor and I have to accuse them.
okay. When you have them, will you please send them to Ms. Champion so that all the cases can be associated together, Ms. Evansville?
Yes, Your Honor.
Thank you. All right, and Ms. McLeod, you had an announcement?
Good morning, Your Honor.
Good morning.
I have one case on the calendar, and we're going to be visiting the issue of bond modification.
Okay, we'll get to that shortly. All right, thank you, Ms. McLeod, for that announcement. All right, and I can see, is that Mr. Dotis at courtroom two? I can only see half your face. Who's at courtroom two from the public defender's office?
Yeah.
Oh, Mr. Judge, I'm sorry. I couldn't see it's still small. All right, are you there by yourself?
No, Mr. Tom White is here as well.
All right, Mr. White is there. All right, and I'm ready to begin with the first position.
We can start with Oconee County.
All right, who is at Oconee County? What number is that? Sir at Oconee County, what's your name? Oh, he's muted.
Your Honor, Oconee has Spurgeon Chester.
Okay. Spell the last name for me.
Chester.
I don't see that party on this calendar today.
Is it on the probation calendar? Do we have a probation calendar?
We have no, we don't have one of those. We have a DB reset, and I don't think he would be on that calendar. Does anyone know?
Yeah, I have a probation calendar and he's on the probation calendar.
Oh, we do have a probation calendar. Why? Oh, no one sent me that. Okay, let me go find it.
What, not that? So
Your Honor, I don't mind speaking to that defendant. I just don't know what the probation's recommendation. I don't have a petition or anything, but I just need a few minutes and I'll speak to him unless Mr. White and Mr. Judd have already talked to him, which I doesn't appear that they have. So I'd be happy to speak.
Yeah, I haven't even prepared this case, so I hadn't looked it up either. Okay, who's here from probation today?
I don't see probation on.
Did probation know we had a probation calendar?
Do you see JCS?
Okay, we're not ready for Oconee County. Can we take another position and please come back to this?
And if we could be forwarded the probation calendar, we were sent the DD bench warrant calendar, but I don't see where we have the bench warrant calendar.
I'll forward everything, Mr. Judd, whatever I have.
Thank you, Mr. Dunn.
I see it. It just didn't travel with state of purpose. And is anyone here from probation today?
Rona, wait a minute. Rona?
Good morning, Your Honor.
All right, good morning, and please tell me your name and state your name for the record as well.
Officer Kitchen.
Okay, Officer Kitchen, if possible, could you email your proposals over to, Mr. Judd, are you going to do the whole probation calendar?
I'm not sure.
There's 4 people I think there's 4 people on there.
Judge,
So-
we won't have any recommendations for any of them, so we.
That's what I was asking. I'm just trying to figure out who's going to do it so that Officer Kitchens can send those offers over for your review.
Your Honor, if the officer can send all the recommendations to all 3 of us, I'll definitely handle with the Coney. I'll need a breakout room. I don't even know if the defendants are physically present in the courtroom.
Judge, we easy probably just put it in the chat and we can play it by ear. I mean, we'll.
Okay, okay. I'll just say okay. All right, can we take another position? We're not ready on the probation yet. Those parties have not been interviewed.
We go to number 6, Mr. Bronner.
Okay, Mr. Brunner this is a bond hearing.
Good morning, Judge. Yes, I filed a bond motion for Mr. Bronner. I'd like to be heard on.
All right, Mr. Brunner, your case is 21 CR 004799C. You're charged with battery, substantial physical harm, battery, family violence, battery, simple battery, family violence, and simple battery. Do you understand your rights today?
Mhm.
All right, thank you. Ms. Stallworth, can I please have the history for position 6?
Good morning, Your Honor. Yes.
Good morning.
He has 16 cycles total. There's FTA in 2026 from Fulton, 2019 from Fulton, 09 from the city of Atlanta. There's a 2018 conviction from Fulton for purchase, possession, manufacture, distribution, and sale of marijuana, possession of cocaine with intent to distribute, and willful obstruction. And then there's an 05 first offender out of Fulton for burglary. Nothing further.
All right, thank you. Ms. Evans Battle?
Yes, Your Honor. I'm not having cooperation. I apologize. I should have had the facts pulled up.
What's his current bond?
His current bond is set at it's a cash bond, and it is set for a total of 3,000. I'm sorry, it's a surety bond. $3,000 surety. It appears to be that was set. And there was no, and that was set on the battery substantial physical harm case, and there was no bond. It says bond set by judge, 0 total cash bond. I don't know what that actually means.
It's a $6,000 cash bond, Judge.
Okay.
Okay, and it may be because he failed to appear, his bond was forfeited. It appears back in His bond was forfeited September 9th of 2022 because he failed to appear for a jury trial on April the 13th of 2022. There had been previous reset for a status conference and a plea and arraignment that took place in October of 2021.
So, and then it converted to a cash bond.
Yes, and so that's why it has the cash bond. This is a case in which the victim in the case is Miss Zachary, and she is also the victim in 3 prior cases in which the defendant has entered a plea of guilty on. This took place August the 21st of 2021, and there was a dispute between the parties. They got into a physical altercation. She identified him as her ex-boyfriend at the time. He came into the home and assaulted her. She said she heard a noise of someone trying to get inside of her home from the back door, and by the time she went to check the back door, he had already entered the home. He attempted to have sex with her without permission, and by starting to pull off her undergarments, she started fighting him. He wouldn't stop, so she pepper sprayed him in the face to get him to stop. She ran and told her kids, who were also in the house, there were 3 of them, to get out of the home. Her brother was also in the home, but he apparently didn't hear anything. He indicated he heard loud noises sounded like that they were fighting. Mr. Bronner was located inside of the home, and he was washing his eyes out. She said that they normally get into fights, and most of the time it's because he is attempted to engage in intimate relationships with her, and without her agreeing to do it. So that has become it was an issue for them back at that particular time. And so those cases in which he pled guilty there were 3 of them that in which he had prior history of battery, family violence, criminal trespass, family violence as well, the property, and another battery, family violence. So that was initially, we had looked at whether or not this would be a case in which to transfer for those number of reasons, not including the breaking into her home. And so our bond recommendation, of course, will remain the same at this particular time. And we did make an offer of a time served plea. Apparently he was just not to take that.
It was just time served, or there was some additional?
There's because it's a battery, there's a statutory.
Right.
Mhm.
Okay, go ahead and put the full offer onto the record, that was rejected, Ms. Evans.
Well, I just want to be clear. I received the offer this morning. So it hasn't been rejected. I sent a clarification email to ask if the charges were concurrent or consecutive, but also I haven't had a chance to convey it to Mr. Bronner because I'm on Zoom and he's in the courtroom. So it's not that it's been rejected, it's that I received it this morning and I haven't been able to convey it to him.
Okay, what's the offer, Ms. Evans?
Count 1 would merge with count 2. Count 2 is 12 months probation, serve 78 days, credit for time served, balance probated, complete the FVIP in 40 hours of community service. Count 3 is 12 months probation, serve 39, it's actually 39 days commuted to time served. Counts 4 and 5 would be null pros, and there would be no objection to non-reporting.
Okay, do you want to call the jail, Ms. Pinto, and speak to your client to see if he wants to take that?
I would. What is the number that I called?
What's the number at courtroom 2 for Ms. Pinto to call?
We'll put it in the chat.
Thank you.
And then I also still, Miss Evans battle, are those counts concurrent?
Yes.
Okay, if we could have a brief recess, Judge, so I can speak to him.
Okay, we'll come back to you. Is there another case we can take in the meantime? Are we ready on any of the probation cases yet?
Good morning, I'm present. I think you were looking for me, so my apologies.
Someone, I think Officer Kitchens responded. Is Officer Kitchens gone? Or are you both doing
No,
calendar?
I'm for the probation case. She's for our intake. She's our intake.
Oh, okay, understood, thank you. All right, are we ready on, I'm sorry, go ahead, Milton.
Position 2 and 3, Miss Allen.
Okay, hold on one second. Did we get the probation offers? I'm sorry. Were those sent over? Did you receive anything, Mr. Haddad?
I have not, Judge. The
Okay.
the case from Oconee County is from 2016. I assume it's going to be a time served close, but I could be wrong.
Yeah,
Okay,
and for
don't-
both probation cases, it will be continue on probation because it's enough time to continue both cases on probation to complete the conditions of probation.
Okay, all right. So with that, is that enough information for your office to speak with the parties, Mr. Haddad?
Judge, I'll be happy to speak to Mr. The client who's in Oconee County.
Oconee. Okay, so can we put those parties in a breakout, please?
And I do have the ACDC, please, Judge. I'll leave it up to the court.
Also, okay, let's take the one ACDC plea and then we'll put you in the breakout with Oconee, okay?
That's fine,
All
Judge.
right, so we're gonna take the plea for Miss Allen. Miss Allen, if that's still the announcement. Miss Allen, you have two cases, 26 CR 003030B. In that matter, you are charged with criminal trespass. You also have an FTA. Do you understand your rights this morning? And that FTA is docketed as 26 FTA 001169. All right. Let's see. We're taking the plea, Ms. Evans-Spano.
Yes, Judge. The recommendation is time served, bound suspended, and stay away.
Yes, Your Honor.
Mr. Haddad did
No,
that.
sorry, Judge. The reason I said it is because when I spoke to Ms. Allen, that was before I got an offer. So I just want to put on the record so she's aware. I told her I suspected that's what the offer is going to be. So I apologize. I'm going to be doing that for the other ladies as well, Judge.
All right, let's let Ms. Evans-Spano still put it onto the record. Go
Yes,
ahead, Ms. Evans-Spano.
it's 12 months served, 30 days, credit for time served, balance suspended, stay away from Grady Hospital unless she needs emergency medical
No,
treatment.
this is the one, stay away from the
Oh,
budget.
okay, no,
tail.
no, I'm sorry. That's the one above it.
Right, stay away from budget tail, correct?
Yes, budget tail, and will not cross the FTA.
All right. Was that your understanding? I'm assuming, yes, Mr. Haddad, that was your understanding. You so stipulate to the three elements?
It is, Judge, and we're ready to proceed with the plea, Judge.
All right, please raise your right hand, Ms. Allen, if you wish to take a plea today. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, ma'am.
You put your hand down. Thank you. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
Did anyone, okay, and you understand you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you understand you're giving up the right to have the state prove these charges, well, this one charge against you beyond a reasonable doubt?
Yes, ma'am.
And you further understand you cannot go back to that budget tail end?
Yes.
All right,
ma'am.
as to the charge of criminal trespass, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from the state of defense?
No, Judge. Thank you.
All right. Best of luck to you, Ms. Allen. We don't want to see you back here. If you don't have other holes, they'll start processing you out, all right? Best of luck to you.
All right, we'll go to position number
Hold
4.
on one, before we go there, are there any other positions at ACDC so we can let Mr. Haddad go in? Are there other pleas we
Yes,
can take
yes,
really quick?
Yes, Your Honor. Ms. Brooks, position 7 and 8.
Okay, Ms. Brooks, let's take that really quickly. Ms. Brooks, your case is 25 CR 003815C. You're charged with loitering and prowling, and you also have an FTA. You understand your rights?
Yes, ma'am.
Oh, you also have the giving false information. All right, Ms. Evans Battle.
Yes, Your Honor, as to count 1, 12 months served, 30 days, credit for time served, balance suspended, stay away from 1720 Vista Avenue. As to count 2, the state would move to null pros that case. As to the FTA, the state would move to null pros that case. We ask that she stipulate to identity, venue, and a factual basis for the plea. Thank you.
Was that your understanding, Mr. Haddad, and you so stipulate?
It is, Judge, and just for the record, Ms. Brooks, the offer is time served, okay?
All right.
Thank you.
All right, Ms. Brooks, if you wish to take the plea, do you please raise your right hand?
Yes, ma'am.
Do you swear or affirm that the testimony given today will be the truth, to the best of your knowledge, and is given under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Thank you. Are
Yes,
you
ma'am.
under the influence of any drugs or alcohol at this time?
No, ma'am, Your Honor.
Did anyone force you to take a plea?
No, ma'am, Your Honor.
Did anyone promise you anything in exchange?
No, ma'am, Your Honor.
And you understand that taking a guilty plea can affect other aspects of your life, such as probation, employment, immigration, or things I may not be able to anticipate?
Yes, ma'am.
And you further understand that you're giving up your right to trial today?
Yes, ma'am.
And you're satisfied with Mr. Haddad's representation of you?
Yes, ma'am.
All right, as to the charge of loitering and prowling, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from state or defense?
No,
No,
ma'am.
Judge.
No, Your Honor.
All right, thank you. Ms. Brooks's case is no longer holding you in Fulton County Jail. Best of luck to you, okay? And is there one more person at
Yes,
ACDC?
yes, Your Honor, one more. And when I finish with her, I will bring back Mr. Phelps
Okay,
after
that's
a
fine.
while.
That'll give Mr. Haddad time to do the interview. All right, who do we have at ACDC?
Position 32 and 33, Ms. McCamby.
All right, and the announcement I have is that this is a negotiated plea. Is that
Yes,
correct?
Judge, it is correct, and if the state, as normal, can put the recommendation on the record. I had told my client again before the offer was made what I expected.
Okay, Ms. Evans Bell, will you go ahead and give us the offer for Ms. McKinney?
Yes, Your Honor, 12 months served, 30 days credit for time served, balance probated, restitution in the amount of $1,000 to AR Financial Services. Stay away from 5195 Old National Highway, complete 40 hours of community service, and complete the anti-theft course. The state will move to null pros the FTA. And she could stipulate to identity, venue, and a factual basis for the plea.
Before I do that, Ms. McCamey, I didn't read you your case number. It's 22 CR 007722H. You're charged with theft by deception. And you also have an FTA docketed as 26 FTA 001172. Mr. Haddad, was that your understanding of the agreement? Do you so stipulate to 3 elements?
Yes, Judge. My only request is if the court, this is 22 case, if the court would consider terminating her probation upon completion of the restitution. There's also community service, obviously, in that class, and I did not mention the community service or the class for Ms. McCamey, but I believe she wants to go ahead and resolve it since it's a time served sentence, Judge.
Okay. Ms. McCamey, if you wish to take a plea with those requirements, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, you can put your hand down. Did anyone force you to take a plea today?
No, ma'am.
Are you under the influence of any drugs or alcohol that would affect your ability to understand the plea at this time?
Yes, ma'am.
You said you are under the influence of it?
No, I'm not. I'm sorry.
Okay, and you understand that today you're giving up your right to trial by judge or by jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
and you fully understand the requirements of the sentence, that you are going to serve a 30-day sentence. However, I believe the time that you serve should satisfy that portion. You're going to pay $1,000 in restitution. You are to stay away from that address on Old National Highway, complete 40 hours of community service, and also complete an anti-theft course. Do you understand all of those requirements, and do you so consent?
Yes, ma'am.
All right, as to the charge of theft by deception, how do you plead?
Guilty.
I accept your guilty plea at this time. Is there anything additional from Ms. Evans Battle or Mr. Haddad?
Your Honor, just my request to consider terminating her probation upon completion of the,
It can, yes, it can terminate.
thank you, Judge.
All right. Best of luck to you. This case is no longer holding you in the Fulton County Jail, okay?
Thank you.
All right. And if we could place Mr. Haddad into the breakout with Oconee County, and we'll go back to courtroom 2. Who do we have at courtroom 2?
We got number 6, Mr. Bronner.
Okay. Are we ready, Ms. Pinto?
I'm sorry. I'm sorry. My bad. Number 4, Mr. Anderson.
Okay, this is Ms. McLeod's case. I was gonna ask if we could do that one next. Ms. McLeod, are you still present? All right, and we're gonna
Yes,
hear,
Your Honor, I am.
we're gonna hold a bond hearing. Okay, Mr. Anderson, your case is 26 CR 004226Y. You're charged with simple battery. In this case, do you understand your rights this morning?
Yes, Judge.
All right, thank you. And I'm assuming that the global offer was rejected, so we'll be conducting this matter on bond. Ms. Stallworth, can I please have his history?
Yes, Your Honor.
There was no global offer. I just wanted to put that on the record.
Okay, give us a second, Ms. McLeod. I can't hear two people at once. Go ahead, Ms. Stallworth.
There are 18 cycles total. There is a 2021 conviction out of Douglasville for DUI, a 2015 first offender out of Cobb County for battery and criminal trespass. There is an open case 25 CR 008214Y for battery and sexual battery. He's currently on probation for reckless driving. Case number 17 CR 023662D. And there's a 2022 FTA out of Fulton, 2021 FTA out of Fulton, and a 2021 FTA out of Douglasville. Nothing further.
All right, and Ms. McLeod, go ahead now. You were saying?
Yes, I was saying there was no global offer.
Okay. All right, let's proceed on bond. Please proceed, Ms. Evans Battle. If you're speaking, you're muted.
All right, yes, Your Honor. This case happened back in June. He's got 2 cases. My computer's not cooperating. Try again. I'm gonna have to try to load the document again. All right, this happened June the 23rd of 2026, in which it was 4 a.m. at 1733 Washington Road in East Point. There was a fight call. The victim is Shaquall, Shaquall Barrett, who indicated that the defendant had assaulted her. She advised that she was released from jail. After her release, she began walking towards College Park Police Department and stated that while en route she encountered him. They engaged in a conversation. And they were walking together. While they were walking, there was contact with someone on a cell phone, and Anderson drove her to a location, and she informed him that she needed to take a shower. He allowed her to use the shower at his residence, which is 2976 Church Street in East Point. She advised that she only had $10 and was willing to pay him to use the shower. He said it wasn't necessary, and after going to the residence and taking a shower, apparently she indicated that she was locked in behind a bathroom door, and was prevented from opening the door. Eventually, the door was opened, and Anderson and an unknown male exited the residence, returned to the vehicle. He requested payment. She indicated she only had the $10, and she stated that she believed Anderson's behavior it was intended to embarrass her in front of the person. While she was seated in the area, he swung at her and multiple times with a closed fist, striking her in the face. And she attempted to shield herself and protect herself, and was eventually able to get away from the situation. And that is why he is charged as is for this particular case. He had the outstanding case, so his bond was set at $4,000 as a surety bond in this particular case.
Okay, thank you. All right, I don't believe the victim is here, but I will sound for Shaquall Barrett. And I know she was also arrested at that time. All right, Ms. McCall.
Yes, Your Honor. First of all, the alleged victim apparently lives in another state based on the address that I saw. I would like to inform the court as to what really happened based on the warrant. Miss Shaquille apparently was walking at 4:30 in the morning. She had been released from jail. She got into a conversation with an unknown man, not my client. She alleges in the warrant that that unknown man called my client on the phone, and my client came and picked both of them up and took them to his house where she had a shower. After she had the shower, apparently she left with my client. That's what she told the police and this other man. And according to her version of things, my client asked her for payment. She said she had none. He was trying to embarrass her, and all of a sudden he started punching her in the face. Your Honor, I read this warrant and I believe there is a lot missing. First of all, the police officers did note that she had no injuries whatsoever on her, but she's claiming that out of the blue, my client just starts punching her in the face. She's someone, she claims she doesn't know my client. He doesn't know her. The story does not make sense. And that is why I believe someone is lying here. Nevertheless, my client is sitting in jail. He's not been able to make this $4,000 good bond. I'm asking for signature bond for him, Your Honor, because he does not have any significant convictions based on what I heard, anything violent in his history. Not recent anyway, and I believe I heard of FTA in 2022, which is quite some time ago. Obviously, he's not been able to make bond. The allegations that strange, I find it difficult to believe what is being said, that someone would engage with two totally unknown men, go to their house, leave their house, get in a car with them. None of the police was not calling all of that. And then the allegations is made after she has left my client that he punched her in the face multiple times. There's no markings or anything like that. She was medically examined and released, Your Honor. I think there's a whole lot more to this story than would meet the eye. And I'm asking for a signature bond for my client. He's been sitting in jail on this charge for 2 weeks now, Your Honor. He cannot make that $4,000 good bond.
Okay.
And I just remind the court, he has an open case for battery, 2 counts of battery, and a different kind of battery in the 25 CR 008214Y, and I'm pretty sure he's out on bond when this new
He is.
offense occurred.
He is, but that does
You
not
said
mean
you had
he-
it, he didn't have any violent
Okay,
history.
defendant is
No.
he's not getting a signature
Significant.
bond. He's not getting a signature bond. I will reduce it slightly to a $2,000 good bond with the same conditions. All right, best of luck to you, sir. This matter is now closed. Is there any anything additional from State of Defense?
No, Your Honor.
Okay, all right.
Your Honor, I filed a motion for discovery, and it's important that I see this interview that the alleged victim had with the police and so on, the body camera footage. This is very important to me.
Okay, so it probably needs to go, you probably need to waive Ms. McLeod so he can get to
Already
it.
waived, Your Honor.
Right, so he can
And
go
I've
to a
also filed a
division.
motion.
Right, so he can go to a motions calendar. There's there's no motions calendars at this level. So,
That
all
is
right.
correct, Your Honor. Mr. Anderson, you may call me from the jail. Ask them to call me if you want to speak. Okay?
All right, he's saying, what is your question very briefly, sir? Remember, you have a right to remain silent and the state is listening to you. Is anything you say against you? What's your concern, or do you want to just call your attorney?
I'll call my attorney.
Okay, all right. Best of luck to you, sir. That matter is concluded for today. Okay, so Mr. Haddad, we're back with Oconee County. Are we ready to proceed on that probation case?
Yes, Judge, we stipulate, I understand probation is recommending
Okay.
time served and
Okay,
reinstate.
hold on,
I'm
Mr.
sorry.
I gotta tell him his case, please. I know everybody wants us to rush on out of here, but let me try to get this together. Give me 1 second. All right, good morning. Who represents probation this morning? Let me swear you in.
Your Honor, Ms. Allen, on behalf of probation.
All right, thank you. Do you swear affirm today that you will make that the testimony given will be the truth to the best of your knowledge, and it's also given under the penalty of perjury today?
Yes, Your Honor.
Thank you so much. I appreciate that. All right, we are here for Mr. Chester Spurgeon. He has 16 CR 00109141, in which he's charged with 2 counts of civil battery back in 2015. The second case on the calendar is the actual probation violation, which is docketed as PV 001497. If we could hear the recommendation from probation, and then we will hear from Mr. Haddad.
Your Honor, Mr. Chester failed to complete the anger management course. He has now been in custody since June 5th of 2026. It is 148 days remaining on his case. At this time, Your Honor, we will be asking for the defendant to be allowed to continue on probation. And also, I will add, that was a 6 weeks anger management program.
All right, and he has sufficient time to complete. Mr. Haddad, your position regarding him completing the anger management that was required?
Your Honor, that's fine. We'll stipulate, I explained to my client what is needed to be done. My only request, Judge, for any back fees that is owed, and I'm not sure if there are, but if there are, to switch them to community service, Judge.
Does he owe back fees?
Unless probation is waiving and just proceeding with the anger management.
Your Honor, I will ask that any of his past due fees be waived, but all fees start as
Right.
as
We'll
of
waive,
today.
we'll waive past due, but he will be required to pay going forward until he completes community service, Mr. Haddad, okay?
Thank you, Judge.
All right. So Mr. Chester, you're getting a second opportunity to resolve this. Please report to probation within 72 hours of your release and begin these requirements, okay? You will not get another chance. However, this will be reported as a probation violation, okay?
Your Honor, can we make sure we get contact information for him so we can make sure he?
Mr. Haddad, did you get information that we can provide?
I did not. If Oconee County can put in the chat line, that might be the best way for his
Okay,
address.
if we could get some contact information from Mr. Chester and have it sent to both probation and Mr. Haddad, we would appreciate it.
Thank you.
All right, is the other party at Oconee as well, or not? Probably not. You're muted, Ms. Haddad, if you're
Sorry,
talking.
Judge. I believe that's the only one in Oconee County, Judge.
Okay, after Oconee County has put that information into the chat, we can Oconee County can be excused.
Thank
All
you.
right, can we take another position at courtroom 2?
We go to position number 54, Mr. Wilkins. From there. And I'm telling you.
All right, I have that this is a negotiated plea.
That's correct, Your Honor.
All right, Mr. Wilkins, your case is 26 CR 004204G. You're charged with simple assault. Do you understand your rights?
Yes.
All right, thank you. Ms. Evans Battle?
Yes, Your Honor. In the case of Mr. Wilkins, the state's recommendation is 12 months, served 90 days. Credit for time served, balance suspended, no further violent contact with officer, right, or law enforcement. Stipulate to identity, venue, and a factual basis for the plea. Thank you.
All right, do you still stipulate, Mr. Judd, and is that your understanding of the agreement?
That is our understanding of the agreement. We do so stipulate for the purposes of the plea, Your Honor. I'd just like to state for the record that he's been in custody since this incident for 31 days.
Okay, understood. All right, Mr. Wilkins, if you wish to take a plea in this case, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes.
All right, thank you so much. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange for taking a plea?
No.
You understand that by taking a guilty plea, you're giving up your right to trial by a judge or jury,
Yes.
and you're giving up your right to have the state prove this charge against you beyond a reasonable doubt?
Say it again.
You understand that by taking a guilty plea, you're giving up your right to have the state prove this charge against you beyond a reasonable doubt?
Yes.
And you further understand that taking a guilty plea may affect other aspects of your life, such as probation, employment, immigration, or other matters?
Yes.
All right, and you understand, and you're satisfied with your attorney's representation today?
Yes, ma'am.
All right, as to the charge of simple assault, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from the state of defense at this time?
Nothing from the defense this time, Your Honor.
All right, best of luck to you, sir. That concludes this case. This matter is now closed, all right?
Thank you, Your Honor.
All right, I need to take a very brief hold. Hold on, everybody, for about 1 minute. Thank you. All right, thank you all for your patience and pardon the interruption. I'm ready to proceed. Is there another position at courtroom 2 that we can take?
Yeah, we got a 45, Mr. Rogers.
I'm sorry, okay, 45. And the announcement I have for Mr. Rogers is that this is a negotiated plea, is that correct?
That's correct, Your Honor.
All right, Mr. Rogers, your case is 26 CR 004107A. Your case is, in this case, you're charged with criminal trespass. Do you understand your rights today?
Yes, ma'am.
Thank you. Ms. Evans Battle?
Yes, Your Honor. The state would ask that whatever time he served be commuted to time served. That stay away from the 201 Piedmont Avenue Southeast location, that he stipulate to identity, venue, and a factual basis for the plea.
All right, thank you. And what was 201 Piedmont? It's nothing medical. I just want to make
It's
sure.
Georgia Building Authority.
Okay, so there's no reason he would need to be there, I don't assume. All right, was that your understanding of the offer, Mr. Jedden? You stipulate to the factual basis, identity, and venue?
That was our understanding, and we do stipulate for the purposes of the plea. For the record, his time in custody has been 18 days as of today.
All right. All right, thank you. If you wish to take a plea, Mr. Rogers, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth and the best of your knowledge?
Yes, ma'am.
Thank you so much. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange?
No, ma'am.
You understand that by taking the plea, you're giving up your right to trial by a judge or jury,
Yes, ma'am.
and you're giving up your right to have the state prove these charges against you beyond a reasonable doubt.
Yes, ma'am.
You understand that taking a guilty plea can affect other aspects of your life, such as employment, probation, immigration, or other matters.
Yes, ma'am.
And you further understand the requirements that you cannot return to that location. However, the time you serve should close your case.
Yes,
All right,
ma'am.
Mr. Rogers, as for the charge of criminal trespass, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from state or defense as it pertains to Mr. Rogers' case?
No,
Nothing.
Your Honor.
All right, best of luck to you, sir. This matter is closed.
Thank you, Your Honor.
All right, is there another case we can take at,
We do 42, Mr. Puller.
okay. All right, Mr. Pullen, he's coming. Mr. Pullen, your case is 26 CR 004097E. In this matter, you're charged with simple battery. Do you understand your rights?
Yes, ma'am.
All right, thank you. Some interesting notes here. Okay, I'm assuming this note about the interpreter is incorrect.
The interpreter is for the complaining witness, Your Honor.
Okay, understood. Is the complaining witness present today? What is her name? Let's just make sure.
The person's name, the person, I don't see them on the Zoom. It's Lee Jiaming, Jiaming, Jaming.
All right, I'm assuming that party is not present, but if, I don't think we'll need to get the interpreter. Is the announcement today, Mr. Jed, that this is a negotiated plea?
That's correct, Your Honor.
All right, Ms. Evans Battle, if you would go ahead and put the facts onto the record, put your recommendation onto the record and any brief factual basis that the state feels is necessary.
Well, I just, it's 12 months served, 180 days, credit for time served, balance probated, complete an MHET, no further contact with the victim, stay away from Peachtree Street and Baker Street, Northeast Atlanta. If I recall the facts, the individual was here for the World Cup event and encountered the defendant on the street, and without provocation, he spat on the victim, which is the basis for the simple battery. And we just ask that he stipulate to identity, venue, and a factual basis.
All right. Do you still stipulate, Mr. Jed, and was that your understanding?
That was our understanding, and we do so stipulate for purposes of the plea. He has been in custody for 17 days as of today.
Okay, thank you. If you wish to take a plea, Mr. Pullen, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange?
No, ma'am.
And you further understand that you'll have no further court dates about this? You're giving up your right to trial today?
Yes, ma'am.
And you're satisfied with your attorney's representation?
Yes, ma'am.
Do you give this plea knowingly and voluntarily?
Yes.
And you fully understand the requirements, including the fact that you need to stay away from that location, have no contact with the victim in this case, and you're going to undergo an evaluation. Otherwise, the time you served in the Fulton County Jail should close your case. Do you understand all of that, Mr. Pullen?
Yes, ma'am.
All right, as to the charge of simple battery, how do you plead?
Guilty.
I accept your guilty plea. All right, is there anything additional from state or defense?
Your Honor, since he does have to spend a significant more time in the jail, we would ask that the first 2 months of probation fees be waived.
All right, I will waive the first 2 months. All
Thank
right. All right. Best of luck to you, Mr. Pullen. That concludes this case. Who do we have next?
Go 43 and 44, Mr. Robbins.
All right, and what is the announcement for Mr. Robbins? I don't have one. I think I need to speak to for 43 and 44, Mr. Judd.
43, 44. Your Honor, it looks like that is a conflict, Ms. McLeod.
Oh, we let Ms. McLeod leave.
That Charles Robbins?
Uh-oh. Can we see if we can get Ms. McLeod back?
Yes, ma'am.
Your
Thank you,
Honor,
Ms. Grace.
that case the state may want to reset for possible felony transfers. I may have it wrong, Judge.
Let me go back and look too. I don't, let me look it up.
It looks like the state was requesting a reset.
Okay.
So I don't think we would go.
Miss Evans Battle, there's no time served offer on 43 and 44, is there?
No. No.
All right, so what, Mr. Robbins, we're gonna try to get your attorney back. If we're unable to get her, the offer given by the state at this time would not release you from Fulton County Jail today anyway. So we may reset you 1 week, but I'm gonna try to get your attorney back so she can at least speak to you to see if there are other options or measures she wishes to take, okay? So we're holding on your case for a moment, Mr. Robbins. Okay?
Yes.
All right. Is there another position we can take?
I take Terrence Patterson.
Number 38, Mr. Patterson.
Okay. All right, Mr. Patterson, your case is 20. Is Mr. Patterson coming? There he is. Mr. Patterson, your case is 25 CR 0080. I'm sorry, come on, Melanie. CR 008400Y. In this matter, you're charged with terroristic threats, and you're also charged with obstruction. I don't have an announcement, Mr. Judd. What's the announcement?
Your Honor, we're requesting a 2-week reset. He has his preliminary hearing for felony coming up soon, and we'd like to get that a little more under control.
Okay, and some more information will need to be gathered. All right, Mr. Patterson, your attorneys have some additional work to do in light of some other cases that you have. So we're gonna reset your case for 2 weeks. All right, what is there room on the 2-week calendar, Ms. Grace or Ms. Champion?
Yes, ma'am, that's 7/21.
Thank you. We'll reset your case there, and your attorney will speak with you, Mr. Patterson, okay?
Thank you, Your Honor.
All right, who do we have next? Ms. Pinto, are you ready on your Mr. Brunner? What is our announcement there?
Yes, Judge, we'll be taking the state's offer and asking for a negotiated plea.
Okay, so Mr. Brunner, we've already read the case number. Ms. Evans Battle has put the offer onto the record. Ms. Evans Battle, before we take the plea, is there anything else you needed to add? I think you gave us the facts And you also gave us the offer at this time. Before I ask if the defense stipulates, is there anything else you'd like to address to the court at this time?
No, Your Honor.
Okay, all right. Ms. Pinto, do you still stipulate to the three elements in this case? And was that your understanding of the offer as previously put onto the record by Ms. Evans Battle?
We stipulate for the purposes of the plea. I don't remember. I know she said time served. I want to be clear that it also includes family violence intervention and community service.
Yes, that was the offer.
So he would have to take FVIP and do how many hours of community service?
It's 40.
40. Okay, so do you still stipulate, and that is your understanding your client wishes to move forward, Ms. Pinto?
Yes, Judge.
All right, Mr. Brunner, if you wish to take a plea today, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury? Is that a yes, sir? Say it as loudly as you can. All right, thank you so much. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
You understand you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you fully understand the requirements, including the course that you have to take and the community service and all the other requirements as explained to you by your attorney?
Yes, ma'am.
Do you take this plea knowingly and voluntarily?
Yes, ma'am.
As to the charges listed in the case ending in 4799C, how do you plead, Mr. Brunner? I accept your guilty plea. Is there anything additional, Ms. Evans Battle or Ms. Pinto?
Judge, I would ask that since he has to do and pay for the family violence intervention program and do 40 hours of community service, and that he's been in jail for over a month and needs to get back on his feet, I would ask that his supervision fees be waived so that he can put the money towards the classes.
Okay, I will waive 3 months of fees in light of the length of the class, Ms. Pinto. Yes, I'll wait 3 months, okay?
Thank you.
All right, best of luck to you, sir. That concludes this matter.
And if you're number one, Mr. Adams.
And Judge, my business is concluded. May I be excused?
Yes, you may. Take care, Ms. Pinto. Have a wonderful afternoon. Bye-bye.
Thank you, you too.
All right, Mr. Adams, your case is Mr. Adams coming? Mr. Adams, your case is 26 CR 004205D. Come forward, Mr. Adams. In this matter, you're charged with criminal trespass. Do you understand your rights today?
Yes, ma'am.
All right, I'm assuming this is a negotiated plea time served. Is that correct?
That's correct, Your Honor.
All right. Ms. Evans Battle, please proceed.
Yes, Your Honor. It's 12 months or 30 days, credit for time served, balance suspended. Stay away from Grady Hospital unless he has a medical emergency. Stipulate to identity, venue, and a factual basis for the plea.
So stipulated for the purpose of the plea, Judge.
Okay, thank you. If you wish to take a plea today, Mr. Adams, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand that taking a plea, you're giving up your right to trial by judge or by jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you fully understand that you cannot return to Grady Hospital unless you're getting medical services provided?
Yes, ma'am.
All right, as to the charge of criminal trespass, how do you plead?
Guilty.
I accept your guilty plea at this time. Is there anything additional from state or defense?
Nothing further from.
All right, best of luck to you, sir. That concludes this case. This is no longer holding you in Fulton County Jail. All right, who do we have next?
ACDC, Your Honor, I have Mr. Phelps.
Okay. Okay, I don't have, do I have one second. Click back. Okay, Mr. Phelps is a negotiated plea, is that still correct?
It is, Judge, and if Ms. Evans Battle can put it on the record, because at the time I spoke to him, wasn't sure exactly, but the offer ultimately, sir, is going to be a time served with probation.
Okay.
And
Right.
which number is that?
He's number 38, 39, 40, and 41. Mr. Phelps, you have several cases today, 24 CR 008181L. You're charged with theft by shoplifting. You also have 26 CR 003957L. In that case, you're also charged with theft by, in that one, you're charged with theft by deception. You have an FTA. Am I missing one? One, two. Okay, then you also have an FTA, which is 26 FTA 001107. I'm sorry, he only has 3 cases, so it'll be 39, 40, and 41. All right, Ms. Evans Battle, please proceed.
Yes, Your Honor, as to the case ending in the 8181L, the state would ask the court to commute whatever time he served to time served in that particular case. That was shoplifting at the food depot. And as to the case ending in the 3957L, it would be 12 months, served 30 days, credit for time served, balance probated, $500 restitution to Leary Moyler. No further contact with Mr. Moyler, with Miss Moyler, her mother or grandmother, and I don't have information that identifies those particular people. Complete 40 hours of community service and anti-theft course. As to the FTA, the state would move to null pros that case.
Thank you. Mr. Haddad, that was your understanding, you so stipulate?
Yes, Judge. On behalf of Mr. Phelps, just for the clerk's numbers, he spent 22 days in custody as of today. So as far as the shoplifting, it'll be 22 days time served. As far as the theft by deception, Judge, it'll also end up being time served. I would ask the court to consider non-reporting probation upon completion of all the conditions. And maybe possibly suspendment of the probation fees for the first 2 months as well, Judge, to get him back on his feet.
All right, I will waive 1 month and he can go non-reporting once he's completed the requirements.
Thank you, Judge.
Mr. Phelps, if you wish to take a plea, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange for taking the plea?
No.
And you understand that you're giving up your right to trial by judge and jury in both of these cases?
Yes.
And you take this plea knowingly and voluntarily?
Yes.
And do you fully understand all the requirements as explained to you by your attorney and as put onto the record by the state?
Yes.
All right, Mr. Phelps, in the case ending in 8181L, how do you, and which you're charged with theft by shoplifting, how do you plead?
Guilty.
And as to the case ending in 3957L, in which you're charged with theft by deception, how do you plead?
Guilty.
I accept your guilty plea. Let's sound for Ms. Moyler. Is there Ms. Moyler present? All right, I accept your guilty plea. And is there anything additional from state or defense as it pertains to either case?
No, Your Honor.
No, Judge.
All right. Best of luck to you, sir. That concludes your case. Bye-bye, Milton. If that concludes everything.
Judge, I'm sorry. With Miss Officer Milton, I did have one additional case that's supposed to be a plea, position 51, Jean Vandenberg.
You said reset for the July 21st? That's what it said on the thing. Okay, all right, give me 20 minutes. I'll be right back. I got one more court to go and I'll take care of it for you.
All right, thank you. Thank you.
Okay,
All right.
have a seat.
We'll see you in a minute, Milton. Thank you.
Okay.
All right, who do we have at courtroom 2?
Number 5, Mr. Barnwell.
All right, I have it. This is negotiated, please.
It is, Judge.
All right, Mr. Barnwell, your case is 16 CR 001570. You're charged with hit and run, failure to signal, and failure to yield. Do you understand your right?
Yes.
All right, thank you, Ms. Evans Spano.
Yes, Your Honor, the state's recommendation is for the hit and run, 12 months probation, complete a defensive driving course, pay restitution if, state would remove that as requirement, based on the fact that this is a 2014 case. If she's not reached out, civilly for restitution, at this point in time. And that she pay a fine and that he pays a fine in the amount of $300 as account to 12 months probation, complete 2 VIP courses and a $300 fine as to count 3, 12 months, $300 fine, stipulate to identity, venue, and a factual basis for the plea.
It will be a total of $900 in fines.
Yes, Your Honor.
All right, so you still stipulate, Mr. White? Now is your understanding of the agreement?
Judge, we do stipulate, a couple of things. We are asking to enter this as a NOLO. And ask that the that the fine be converted to 90 hours of community service and ask that his probation terminate upon completion. This is over 12 years old.
All right, it can convert to community service. It can terminate when he's completed, and I'll allow him to plead no low. All right, Mr. Barnwell, if you wish to take a plea, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes.
All right, thank you. Put your hand down. Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange? Was that a yes?
Yes.
I'm sorry, let's ask it again. Did anyone promise you anything in exchange for taking a plea today?
You can promise anything outside. Yeah, outside of what you're talking.
Okay, I'm sorry, say it again. I didn't hear you.
Yes, no. No.
Someone promised you something for taking a plea? I don't think they did. Did anybody offer you any gifts in exchange for taking a plea?
Oh, no.
Okay. And are you satisfied with Mr. White's representation?
Yeah.
Are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding?
No.
Do you take this plea knowingly and voluntarily?
Yes.
And do you fully understand all the requirements?
Yes.
As to the charges in the case ending in 1570A, how do you plead, Mr. Barnwell?
Guilty.
I accept your guilty plea. Best of luck to you, sir. I'm gonna waive that, what was it, 1 month's of fees, and he can do the 90 hours of community service instead. I'm sorry, it was supposed to be a no-low plea. As to the cases, how do you plead, Mr. Barnwell?
No.
All right, I accept your no-low plea at this time. Is there anything additional from state or defense? All right, best of luck to you, sir. Who do we have next?
Thank you, Judge. Number 9, Mr. Cosby.
All right, I don't think I had an announcement for that one.
Judge, 1 second. No. Your Honor, we are going to enter a guilty plea today. He is asking that he be allowed to enter a no.
He's asking to enter a no-low?
That's correct.
Okay, Mr. Cosby, your case is 26 CR 004122G. You're charged with obstruction and simple assault. Do you understand your rights?
Yes, ma'am.
All right, in light of the no-low plea, Miss Stallworth, can I have the history to see if I'm gonna permit that?
Apologies, Your Honor. Who's the, what position? I'm sorry.
Position 9, Cosby.
Cosby, okay. 1 moment. My computer is loading. 1 moment. Okay. He has 14 cycles total. There is a 2019 conviction. One moment, hold on. He's currently on probation for 18 SC 160269 for possession of firearm or knife during commission, aggravated assault, and receipt, possession, or transport of firearm. There is an FTA in 2012 from Henry County and an FTA in 2010 from Rockdale County. And then there is a 2012 conviction out of Henry County for theft by taking and fleeing or attempting to elude. There is a 2010 out of Rockdale for stalking.
Okay, I think that's sufficient.
That's
Mr. White, if he takes the plea, Mr. White, I would require him to plead guilty. Does he still want to take the plea today?
He says that those charges weren't him. He's never been to Rockdale County, so I'm not sure. And I didn't hear any NOLAs in the last 5 years.
Was it Michael Anthony Cosby?
I don't have a middle name.
Okay, one moment. I'm sorry. Maybe that
Let's
was.
check the birthday.
3659. No.
Okay, wait. My apologies. Hold on. That was the wrong Michael Cosby. Okay, I have the right one now. My apologies. Hold on. He has a very lengthy history, Your Honor. One moment. Let me see.
Okay, yeah, I do that.
He has
Your
92
Honor,
cycles.
he has 92 cycles is what I
Yeah.
have for a history. And I have, he has a prior obstruction that we noted from the 2021. He has a couple of PI cases. And I say that he has, actually, I see 2 obstruction cases in the last 5 years. And 3 PI cases. And this incident was one in which the officer saw him using a bathroom and did not charge him for that, but he assaulted the officer. And
Okay. So, Mr. White, I'm still gonna, if he wants to take it, it'll be a guilty plea. Does he want to take the plea today?
Can I have 30 seconds, Judge?
Sure.
Waiver.
Okay, he's gonna be a waiver?
That's correct.
All right.
You ain't never no goddamn me. I didn't say we did nothing. I didn't say I weighed nothing. You ain't speaking to me, okay?
You want to represent yourself?
Oh.
Okay. Judge, we're in an impasse here.
Okay, so Mr. Cosby, I'm unclear does Mr. Cosby need to come back? He wants to take the plea?
He doesn't want to take a plea, but I think he needs to be arraigned. He doesn't want to.
Okay, so we're gonna arraign his case. Ms. Champion, will you please send me the accusation, if you don't mind? We're gonna skip Mr. Cosby for now. We'll come back to him and we'll arraign him and set him for trial at a division. Thank you. Once I have the accusation in hand, we'll do Mr. Cosby. Can we take another position in the meantime?
Candidate number 18, Mr. Gilmer.
All right, I have the that's a negotiated plea. Is that correct?
No, Judge. The case that's on the SAP calendar is a waiver, but he is also on the probation calendar, so that's what we.
Okay, so we're gonna put down the waiver for number 18. And we'll take up the probation revocation. Give me a moment to get back to that.
It just makes sense.
Okay, finally found it. Okay, okay, I'm sorry, forgive me. Okay, Mr. Gilmer, you have a case on the SAP calendar. Your attorney has already reset that one for trial. There's gonna be some additional development. You also have case 15 CR 006580H, in which you're charged with theft by taking. Then you have the probation violation itself, which is docketed as 26 PV 001445. I'm first going to hear from probation regarding their recommendation, then I'll hear from your attorney. Reminding you that you're still under oath. Officer Allen, would you please proceed?
Your Honor, the defendant was ordered to complete a shoplifting course, 40 hours of community service, as well as pay probation supervision fees and pay a fine and court costs of $275. Your Honor, the defendant has failed to provide our office with the completion of the course in community service. He's failed to pay the fine in full. Your Honor, he has been in custody since June the 17th. It is 218 days remaining on his case. Your Honor, I will be asking for the defendant to be allowed to continue on probation.
All right, Mr. White.
You have to go back to probation. Judge, I mean, unless you would consider commuting it to time served, considering this case is 11 years old at this point, we would accept that. But I mean, I think this case is so old, maybe just commuting the time served.
I'm not gonna do that at this point. What I'll do is I'm gonna accept the recommendation given by probation. I understand he has some cases, upon his release, he's gonna be required. How much time does he have left on probation?
218 days.
He has enough time to complete that.
This was
So I'm gonna,
this was a told warrant, Your Honor.
okay. So I'm gonna, accept probation's recommendation and report this as a probation violation. And upon his release, he will be required to report probation and, complete those requirements. Okay?
Judge, yeah, you should be released. Okay. All right, thank you, Judge.
All right.
Your Honor, that concludes my business. May I be excused?
Yes, you may. Take care.
Right,
Thank you.
All right, number 19 and 20, Mr. Granger.
Okay, do I have an announcement for, what's the oh, this is a negotiated plea. Okay, is that still the case?
That's correct, Judge.
All right, we waive sounding on the facts for this case. Mr. Granger, your case is 25 CR 007082A. There's a charge I won't sound. You also have an FTA docketed as 26 FTA 00181189. You understand your rights?
That's right.
All right, I saw Ms. McLeod. Ms. McLeod, you reappeared. You have one other client on the case. The state has asked for a reset, Ms. McLeod. Do you wish to speak to your client while we and give the jail a call while we continue?
I've already spoken with him, Your Honor.
Okay, so is there any other development, or is the 2-week reset sufficient?
Your Honor, my client really wants to get out of jail. So I guess we should address the issue of his bond.
Okay, so we'll do that. We'll do that after. We'll do that after Mr. Granger. Okay. All right.
Yes, Your Honor.
Thank you. All right, Miss Evans Battle.
Yes, Your Honor. It's 12 months served, 60 days, credit for time served, balance probated, complete an SDET, no further contact with Keith Barber. stay away from North Avenue, the Marathon gas station at that location, and stipulate to identity, venue, and a factual basis for the plea, and we would move to null pros the FTA.
That was your understanding, Mr. White, you so stipulate?
It is, Judge, we do stipulate the purpose of the plea. I do just have a question about the time he has been injured. This is originally arrested on this on the 8th of April 2025. So I just want to give him an idea of what credit he has.
Okay, I'm sorry, you're asking how many days he has in jail, how many days he served?
That's correct.
Okay, Ms. Champion or Ms. Grace, can you tell me how many days you see? Or Ms. Evans Battle, how many days has he served? All right, we're still. Ms. Evans Battle, if you're speaking, you're muted.
Judge is showing 9 days.
Okay, so he would have some.
No, he has more than that. Right?
Yeah, he should.
He has 9 days on the FTA for this particular case, but this happened back in April of 2025. Wow.
Yes, 4/8/2025.
I don't actually see an additional arrest, prior arrest noted for this case.
So he
That's
did
why
20
there's no days on here.
27 He said he did 27 days at the time of arrest.
Does anyone else see that? Because
Okay,
Grace
let's
only
look
is
at a
seeing-
different location then.
He was in Alpharetta for some time, but I mean, that's still Fulton County. We should be able to confirm that. Or is it pre-trial? Okay, actually, he was in pre-trial for that. And he's been in Alpharetta before he came over for this. They picked him up on this in Alpharetta.
This case was accused. He didn't have a first appearance for bond. This was one of those cases that
he sat in Alpharetta, and it was that exactly lines up with what he told me, that he was in Alpharetta or pre-trial or Alpharetta. I'm not sure. Well, Alpharetta this time when they picked him up on the warrant, so he should be credited.
I don't know. This is a bind over case.
Yeah.
Okay, so we're seeing. Let me try to look at it myself. So it's unclear. Mr. White, I don't think it's. I understand and I agree with you about the Alpharetta time, but I don't see it either. So the problem is, even if we say it I get you. I'm hands in the air, but the problem is when they go to release him, if it doesn't show. Let me look one place else.
Mm-hmm.
I think the law is that anytime he serves, since that charge has been pending, would be applied. But if it doesn't show, you're going to have when the jail goes to process him out.
Well, that's a problem. That should show.
I get it, but it's not showing at all. I don't see it. Does anybody else see it? And again, I am not the most astute at looking these types of things up. I concede.
What was the violation date?
4/8/25.
That's the original date, and then
that's the violation. So she could look up the violation to see if there was time docketed. Then it's the point, and then.
So he went to. This is a bind over from Municipal Court of Atlanta. We received it in our office in June of 2025. He was set for a plea and arraignment on June the 3rd of 2026, and he failed to appear, and he was subsequently picked up on that warrant. It looks like our C calendar date is July the 3rd of 2026. I mean,
Okay.
yeah, so that's what I have. And that's why he has the 9 days.
Well, that's 11 days anyway.
No,
At the very least, if he
I
was
don't
on.
do math. I must admit. I'm just looking at the jailing is indicating it's 9 days as of today.
Is there any way we could do this just as 18 days? Considering, I mean,
If is the state willing, I'll let Ms. Evans Battle address that.
Oh, I'd have to look up his history. I mean, if we ask for 60 days, then
and
he
he's
has
done
to-
it, then he's still done that time. It's just a matter of manipulating the sentence. And we'll write on the sentence sheet if you want to, time of pretrial detention. He's been arrested. He said they picked him up on the 19th. So at this point, that's at least 18 days. And we still believe he was arrested. He did time when he was initially arrested. Back in April of 25.
Just let me, no, because I do recall what the facts of this particular case is. This is not a simple.
Okay.
Even
So
if you're getting what you asked for, as far as the amount of time you spend in jail. I mean,
I think the problem is you can't see it anywhere, Mr. White, and I get that, but okay, do we have something that shows?
The offer is based upon, and the other thing the offer is based upon is what we show as having the time for arrest. I mean, when we make our recommendations, we do look at how much time they've been in there. And if we are asking for more time than what we see, I mean, and that's what this particular case is. It's
that's
not
it.
just looking in there.
You're asking for him to do a 60-day sentence, which is 30 days, and we're saying that he's done it. So you think too. We're gonna need a minute. So, I mean, if we're not willing to move and he's just gonna get credit for 9 days, which is just an absurd number, based on the time he was in SEA, we know that it was at least 2 more days. I'm gonna need a minute to talk to him.
Okay, Mr. White, where can we, does anybody know how we can see the time that he was in pretrial to get the exact number of days? I can't see it.
In pretrial detention?
Mm-hmm. Because they're saying he was at Alpharetta. I don't see that. I believe you, Mr. White. I don't know how to see that.
Can someone from the jail look that up? This
Right. Is there a jailing information at the jail that can show us that he was in Alpharetta?
That would require us to be in the 20th century, let alone the 21st century technology.
Okay. Well, what I'm saying is,
couple of calls. He's going to call pretrial and Alpharetta and see if we can get any.
okay, because what would happen, Mr. White, is the rule, the new law, however, is if you have information that he did serve there and somebody can show something, that would essentially be the time. But the problem is looking at the different screens, I don't see it, and I'm concerned that no one else would see it when it was time for him to take the plea. Why don't we take a few minutes and come back to this one?
Okay. Thank you.
Okay. All right. I understand your frustration, but I don't know how to get around it. All right. Can we take the ACDC position?
Yes, position 51, Your Honor. Ms. Vanden.
All right,
Thank you,
Ms.
Ms. Milton.
Ms. Vandenberg, your case is 26CR004089C. You're charged with battery, family violence, and simple assault, family violence. You have an absolute right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney today, and Mr. Haddad is present to assist you. And as you can see, I'm conducting this hearing by video. Do you understand your rights and how I'm conducting the hearing today?
Yes, ma'am.
All right, thank you. I have that this is a negotiated plea. Is that correct?
It is, Judge, and if the state can put it on the record, the only question I was not sure about the stay away or not, but there's no further violent contact. My client just needs to be aware of that, Judge.
All right, Ms. Evans, why don't you put the offer on and clarify the state's position regarding a stay away?
Yes, we've had an opportunity to speak with the victim in the case, and there's no stay away needed. So our recommendation as to count one is 12 months, served 30 days, credit for time served, balance probated, complete the FVIP, no further violent contact with William Joyner, and stay away is not needed. Count two, 12 months probation, complete 80 hours of community service, no further violent contact with William Joyner. Stay would ask that she stipulate to identity, venue, and a factual basis for the plea.
All right, do you so stipulate, Mr. Haddad, that was your understanding?
Yes, Judge, I would just ask the court to consider waiving the first 2 months of probation fees since there's a cost associated with the Family Violence Intervention Program classes.
All right, I will waive 2 months. All
Thank
right, ma'am, if you wish to take a plea, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding today?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand that today you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you fully understand the requirements of the sentence, including the fact that you have to have no further violent contact with Mr. Joyner. You're going to do community service, take a family violence class. Do you understand all the requirements as explained to you by your attorney?
Yes, ma'am.
And do you take this plea knowingly and voluntarily?
Yes, ma'am.
As to the charges previously listed in the case ending in 4089C, how do you plead, Ms. Vandenberg?
Guilty.
All right, I accept the guilty plea at this time. Is there anything additional from the state or from the defense?
No, Judge, thank you.
No,
All right, thank you. Before ACDC leaves, I just saw a note that Hubbard is at ACDC as well. What is the announcement for Hubbard, Mr. Haddad? Oh, Hubbard's not. Okay. Thank you then, Milton. Take care.
Bye.
Bye-bye. Okay. If we could take Miss McLeod's case.
He's right here.
Okay, and I guess we're being heard on bond for Mr. Robbins. He has position 43 and 44, case 26CR001513G, in which Mr. Robbins is charged with simple assault and disorderly, and then 26CR005235G, in which he's charged with battery. Ms. Stallworth, can I please have the history for 43 and 44?
Yes, Your Honor. There are 25 cycles total, one from the state of Alabama. There's a 2019 conviction out of Fulton for giving false name, a 2019 conviction out of Fulton for driving without valid license, an 06 conviction out of Fulton for disorderly conduct, and a 2000 conviction out of the city of Atlanta for willful obstruction. There's a 2021 FTA from Fulton, 2019 FTA from Fulton, 2018 FTA from the city of Atlanta, and a 2015 and 2014 FTA, one from Atlanta, one from Fulton, nothing further.
All right, thank you. Ms. Evans Battle?
Yes, Your Honor. As to, I think the case that's actually holding him is the battery case under the 2356G case, if that's correct.
Okay, is that what's holding him in?
That's the $3,000 surety is on that case. I pulled up the wrong screen. So the facts of that case is that the officer, this happened June the 22nd of 26. The officer was riding past 901 Joseph E. Boone Boulevard Northwest, and he observed Mr. Robbins on top of a female striking her in the face. He was identified, and the female is Kristen Cobb, who's the victim in the case. It appeared that they had no prior relationship to one another. I know that there's a video incident of this instance because I just so happened to watch it as well. So the surety is set in the amount of $3,000. He already had that open case, as well as the FTAs, which is why the surety is in place. We do have our offer is not going to be a time served, which is what we believe I explained that to Ms. McLeod. On that particular case, we were trying to work out a global offer.
All right, Ms. McLeod?
Yes, Your Honor, I am of the opinion that he's been in jail long enough that an appropriate offer should have been on the table. There is an offer in one of his cases, the one that happened earlier in the year, and my client was inclined to accept that offer. I thought that might have been the global offer for resolution, but my understanding is that it is not. Therefore, I want to address the issue of his bond, Your Honor, because he's not in a position to pay for bond. I didn't hear anything in his history. It just that he had these many cycles, but it does not sound that apart from the FTAs, that there was any significant conviction, Your Honor. He tells me that being in jail, he's lost the job that he had, his circumstances have been much reduced. He's just been trying to get on his feet, Your Honor, when all of this happened. And I believe I have not seen the video, although I filed for discovery. So I don't know what the allegations are, but of course he denies that is what occurred and that he was a primary aggressor in all of this, Your Honor. And I don't think that he has any real violent history, even though pre-trial said he had these many cycles. They seem like they were mostly FTAs and matters of that nature.
All right. How many times has this case been on SAP?
I think this is the first time, Your Honor.
Okay. Bond is gonna remain as set. However, I'm gonna reset him 1 week with the expectation that the state will have a global offer for him at that time. All right.
Thank you, Your Honor.
All right. Best of luck to you, sir. That concludes this case. We'll be revisiting it next week. All right, Ms. McLeod, thank you for coming back. Take care and have a wonderful
You're
afternoon.
welcome. You too, Your Honor. Thanks.
We got 22-23, Mr. Hubbard.
All right, and what is the announcement for this case? I'm waiting for Mr. White. Mr. White, your announcement?
1 second, please, Judge. We're juggling a lot of stuff here.
I understood.
Will you come back?
Yes, Mr. Hubbard is negotiated plea.
Okay, thank you. All right, Mr. Hubbard, you have 23 CR 002848Y, you're charged with obstruction. You also have an FTA docketed as 26 FTA 001171. Ms. Morgan, please proceed. If this is your case. We can't hear you.
Can you hear me now?
Yes.
Okay.
Go ahead, please proceed.
Yes, Your Honor. For the case ending in 2848Y, the state's requesting that the defendant be sentenced to 12 months of probation, have served 30 days, credit for time served, I am sorry, there's an abbreviation that I'm not familiar with, OP21.
Oh, the class, the law and opportunity. Is that what that's supposed to be? Miss Evans Battle?
Operation 21 Law.
Yeah, that
Yes, Your
class.
Honor.
Mhm.
Balance probated and that the defendant have a $300 fine and the defendant stay away from 2450 Camellia Lane, CAMELLIA, and no further contact with Antonisha Holman. Antonisha is spelled ANTONESHA. Holman is HOLMAN.
Okay, thank you. Mr. White, was that your understanding of the agreement? Do you so stipulate?
Yes, Judge, it is our understanding. We do stipulate, we would just ask to waive 2 months of probation fees and allows probation to terminate once he completes the.
All right, I will waive 1 month of fees, and once he's completed, he can probation will terminate. Mr. Hubbard, please raise your right hand if you wish to take a plea today. Do you swear or affirm the testimony you give today that the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time that would affect your ability to understand this proceeding?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange?
No, ma'am.
You understand that by taking a guilty plea, you're giving up your right to trial by judge or jury,
Yes, ma'am.
and you're giving up the right to have the state prove these charges against you beyond a reasonable doubt.
Yes, ma'am.
You fully understand the requirements as explained to you by your attorney,
Yes, ma'am.
and you're satisfied with Mr. White's representation.
Yes, ma'am.
As to the charge of obstruction, how do you plead?
Guilty.
I accept your guilty plea at this time. Is there anything additional from State of Defense?
Yes, Judge, I do have one question for case managers. We need to know if he has another case, and we want to know if there's a filing for a private counsel on that case.
It's a felony case, or it's one of our cases?
It is a felony case. It's
Let me try to look it up too.
20
Go ahead, I'm sorry.
25 SC 000654.
Okay. And then Ms. Grace or Ms. Champion, if you could look that up for me as well.
Judge, I'm showing Shanna B. Render.
Okay, so that case number might not be right, Mr. White. Do you have can we look at, let me see.
You mean an entry, or you have an entry from that person? Is that what you're saying? No.
Look myself.
Are you speaking of the theft by deception case from 2023? Is that the case you're speaking of?
No, I gave the case number 25 SC 3000.
That side of the screen.
654,
Yes,
Spencer Hubbard.
correct.
And what's his I guess the question Mr. White had was, does he have a bond on that one?
He does not have a bond on it, I don't believe.
I thought his question was private attorney. What's the question?
Right. Is there a private attorney?
Don't see an entry. He looks at one of them. I do see a name attached to it.
All right. The judge.
The attorney name is Shanna.
Okay. That's what-
SHANNINB Render. RENDER. Retained 3/26/2025. I'm not showing an entry.
Okay, perfect. since there is no entry, he was interested in having a public defender on that case. I'll let him know that we can do that.
Okay. All right. Is there anything additional?
Nothing, Judge. Thank you so much.
Okay. All right. Best of luck to you.
We have information on, go back to 19. Mr. Granger.
Okay.
So Mr. Judd was able to contact both ACDC and Alpharetta, and they said that he was in ACDC from May 7th of this year until the 18th. And then from the 18th, they transported him to Alpharetta for whatever reason, and he was there from the 19th to the 29th. So he's been in custody constantly on this case since May 7th.
Okay.
Which is 60 actual days.
Hold on. All right. So, Ms. Evans-Bell, are you present? So the jailing screen has shown that he served 60 actual days. So essentially what will happen is, Mr. Granger, if he takes the plea today, it would be a time served plea because the jail is gonna, I think there's a law, and I don't know the case offhand, that says any time that you serve, it's credited towards the case.
And Judge,
And so I think Mr. White has provided the information. You have that information that we can attach to the order, because what's gonna happen is even if you write it in, if the jail doesn't show it on their screen, he's not gonna get out.
right, I understand that, Judge, and because we don't have it, and somehow or another, Fulton County, all these institutions aren't connected, and they're just going to see 9 days, and then they're going to keep him another.
I understand. That's fine. The 18 days, that's fine. If
Thank
you have that information, then that would be fine with me.
And like I said, I don't have it on paper. We just called and asked them, but it's Office of the Court. I can tell you that's what they told us.
All right, so we're gonna make it 18 days, okay?
Thank you, Judge.
All right, Mr. Granger, if you wish to take a plea, please raise your right hand. Do you swear or affirm testimony you give today be the truth to the best of your knowledge?
Yeah.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange?
No.
You understand that by taking the plea, you're giving up your right to trial by judge and jury?
Yeah.
And you fully understand all the requirements as explained to you by your attorney?
Yes.
And you understand, and you're satisfied with Mr. White's representation?
Yes.
As to the charge, I won't sound, and in the case 7082A, how do you plead?
You.
I accept your guilty plea at this time. Is there anything additional from State of Defense?
No, Your Honor. Thank you.
Your Honor.
All right. Best of luck to you, sir. That concludes this case.
Thank you.
And did you want to arraign Mr. Shelby real quick? We ready to do that?
Okay, well, before we do that, are there any other pleas we're gonna take? I'm gonna do that if we can last. Or is Mr. Cosby the last thing we can do?
Okay, Mr. Come on. Number 27, Mr. Cooper.
All right, that's a negotiated plea, Mr.
No,
White?
no, Judge, we're asking for a bond hearing.
Okay. Number 27, Mr. Kunta, your case is 26 CR 004200E. You're charged with theft by receiving. Do you understand your rights?
Yes, ma'am. Yes, Your Honor.
All right, Ms. Stallworth, can I please have the history for position 27?
Yes, Your Honor. I'm trying to pull it up. Give me just a moment. He has 11 cycles total. There is an FTA in 2026 out of DeKalb County. There's a 2026 conviction out of DeKalb for criminal trespass and battery. There's a 2026 conviction out of DeKalb for simple assault and theft by shoplifting. There's another 2026 conviction out of DeKalb for theft by shoplifting. One moment. Another FTA in 2014 out of Fulton. And then it's showing a whole. One moment. Let me see where that's from. Out of Ohio for a parole violation. Date of that warrant is November the 22nd of 2024. Nothing further.
All right, thank you. Ms. Morgan?
Yes, Your Honor. So this case occurred on May 2nd of 2026 in at 1722 Campbellton Road, Southwest Atlanta in Fulton County, Georgia. Essentially what happened was that the victim, Tyra Williams, left her fanny pack inside of her vehicle. She came back the next day and it was gone. A convenience store employee found the fanny pack inside of the store, called police, and video showed that the defendant was in the store with his backpack as well as the fanny pack. He went through the fanny pack, gathered things out of it, being passport, money, as well as other identification items, and he discarded that fanny pack there in the store. Officers later did catch up with the defendant, and that's what transpired in this case. At this current time, Your Honor, the state is requesting a $1,000 surety bond, and that the defendant stay away from the 1722 Campbellton Road, Southwest Atlanta location, and have no further contact with the victim, Tyra Williams.
Okay, Mr. White?
And Your Honor, he has no problem with any stay away orders or that you like to place on bond. He does deny the incident. He has been in jail now 15 days. He's got $1,000 good bond. We're just asking to convert that to a signature bond. He was unable to make that bond. He's received news that his daughter just died 3 years ago. And additionally, his mother has breast cancer that he helps take care of. His record wasn't spotless, but it didn't sound that.
Okay.
What was it? So we're asking to be allowed to sign his own bond so that he can get to his daughter's funeral and help with his mother.
When was the last theft by receiving? I'm sorry, Ms. Stallworth. He had another theft by receiving? He's not gonna be eligible for straight through the jail if that's the case.
One moment. I do see a 2014 theft of service, but let me go back to the DCIC to see
Okay.
what I said about this.
Let me look it up too. I think
There's a 2026 theft by shoplifting out of DeKalb.
okay. So the best I could probably do, Mr. White, is a dollar cash bond if you want to go with that.
Okay, Judge.
All right, the defendant is gonna receive a dollar cash bond with the same stay away and no contact provisions. He will be reset for the note. In light of the cash bond, if he doesn't make it, I guess he gets reset again, unfortunately.
Well, just put him on. There was no offer from the state on this case, so if we would, we could reset him the next week if he's
If
here.
he doesn't make the dollar, okay.
Not here, perfect.
All right, reset next week. All right, best of luck to you, sir.
Thank you, Judge.
Excuse me, Joe, what position was that?
27,
Thank
Mr.
you.
Coulter.
That's the bond.
Yes.
All right, is there, what about 25 and 26?
That's gonna be a waiver, Judge. Same position 24, I would like to address 24. He's not in court, we did waive it, but we're asking that the cruelty charges be dismissed As there's no battery family violence charge for those that follow. It's a simple battery charge.
Okay, I'm gonna ask Miss Evans Battle to take a look at that. Otherwise, since it's been waived, Mr. White will probably need to go to a division motions calendar. But I understand your position. All right.
We just, I understand, and it was our intent to know across those cases. That's one of the cases I believe that we're waiting for victim contact on, correct?
That's correct, Judge. There's no offer.
And so we were just gonna take care of everything at one time.
Okay. All right. So we're back to Mr. Cosby. Is that the last case that we have?
I believe so, Judge.
Okay, Mr. Cosby, you and your attorney reached an impasse. You don't wish to take a plea today, so I'm gonna arraign your case, which means
I'm gonna take a plea today, get it over with.
Are you sure?
I'm gonna
Yeah,
Let's speak to Mr. White.
Oh, where's Mr. White?
Mr. White's your attorney behind you. I'm gonna let him speak with you, okay? In the meantime, if that's the last position, can we go ahead? Well, let me see. Let's just hold for 1 second. What about position 36, Mr. Mitchell? And he's 36 and 37. I didn't have anything for that one.
That was a not guilty waiver, Your Honor.
Thank you.
Yes, sir.
Your Honor, I do have one announcement, a correction, actually, I should say.
Okay.
Your Honor, on position number, I'm sorry, Judge, 17, Durr, I'm requesting a reset to the competency calendar on the 23rd of July.
Did you already enter the request for the evaluation?
No, Judge. Normally what happens, just so the court is aware, we set it as a placeholder so the social worker and Mr. Bartels to go talk to her, and assuming she is in fact, I mean, many of our clients have mental health challenges. The question is whether it reaches competency or not.
Right, I understand. The problem is you technically can't go to that calendar without either an eval having been done or a pending eval.
Well,
so
I'll just keep my waiver arraignment then. Let the trial figure it out.
What we can do, I don't want her to get lost in the system. Let's put her on a Thursday SAP. And when is the social worker set to come?
Judge, if we can reset it for next Thursday is fine.
Okay. I'll put her on regular SAP for now. Let Mr. Bartels know that if she does do something, we can move her from that point. Can we put number 17 on next Thursday, please?
Yes, ma'am. That will be the 16th of July.
Thank you. Thank you so much, Ms. Champion.
Thank you.
Thank you, Ms. Champion. Right.
Thank you, Judge.
Thank you. All right. All right, Mr. White, are we ready for Mr. Cosby? Is there any additional development?
Judge, we're actually asking for a 1 week reset on Mr. Cosby.
Okay, just to further discuss the pending offer.
Sure, we can call it that.
I need some. Give me something, Mr. White. Was it a time served on the?
It was not, Judge.
Okay. All right, we're gonna reset Mr. Cosby 1 week. Is there any additional development from anyone before we begin our calendar review? I see a party named Anna Catalina. Ma'am, can you tell us why you're here today?
Your Honor, that's the DV case.
Oh, okay. All right, please hold. We're gonna get to you shortly. And Mr. White, are you doing that calendar?
Sure, Judge. Let me just give her a number to call.
All right, if you can you put it in the chat, Mr. White? Are you able to do that? Everybody who's here for the DV reset calendar who would like the assistance of the public defender's office, please look at the chat for the phone number for you to call and so that they can assist and prepare you. In the meantime, can we review our SAP calendar, please?
Yes, we have her as the only one. I'm gonna make sure that's.
I don't think that feels wrong, but perhaps I'm wrong. Hold on.
Yes, it's just one case for the
It's
DV.
just one. I got lucky today. Okay. So, ma'am, if you'll go ahead and give Mr. White a call and we'll review the calendar.
Yeah.
Position number 1 was a plea. Position number 2 was a plea. Position number 3 is a no-pros. Position number 4 was a bond hearing, amended bond to a $2,000 good bond. Position number 5 was a no-low plea. Position number 6 was a plea. Position number 7 was a plea. Position number 8 was a no-pros. Position number 9 is going to be reset to the SAP 714. Position number 10 is reset further notice jail jury. Position number 11 is reset to the SAP competency calendar on 723. That's position 11, 12, 13, and 14. Position number 15 and 16 is going to be reset further notice jail jury. Position number 17 is going to be reset to the SAP 716. Position number 18 is reset further notice jail jury. Position number 19 was a plea. Position number 20 was a no-pros. Position number 21 is reset to the SAP 728. Position 22 was a plea. Position 23 was a no-pros. Position 24, what was the announcement? I'm sorry.
It was, there's no offer on that matter.
It's a waiver.
Oh, it's a waiver. And there's gonna be a what's the word I'm looking for? A non-process of one of the charges.
Okay. Position 25 is reset for the notice jail jury. Also, the announcement for 26. Position number 27 is going to be reset to the SAP 714. The bond was amended to $1 cash. Position 28 is reset for the notice jail jury. 29 is reset for the notice jail jury. Position 30 is going to be reset to the SAP 714. Position 31 is reset for the notice jail jury. Position 32 was a plea. Position 33 was a no-pros. Position 34 is reset for the notice jail jury. Position 35 is reset for the notice jail jury. Position 36 is reset for the notice jail jury. Position 37 is reset for the notice jail jury. Position 38 is reset to the SAP 721. Position 39 was a plea. Position 40 was a plea. Position 41 was a no-pros. Position 42 was a plea. Position 43 is going to be reset to the SAP 714. Position 44 is also reset to the SAP 714. Position 45 was a plea. Position 46 is reset for the notice jail jury. Position 47 is reset for the notice jail jury. Position 48 is reset for the notice jail jury. Position 49 is reset for the notice jail jury. Position 50 is reset for the notice jail jury. Position 51 was a plea. Position 52 is going to be reset to the SAP 721. Position 53 is reset to the SAP 721. And position number 54 was a plea. Any questions or concerns?
All right, hearing none, we'll take a few minutes before we begin the 11 o'clock calendar. Those who don't need to remain with us are free to go at this time.
Miss Anna Cantalina, can you hear us? There was a number provided to you in the chat. Could you give that a call, please? Thank you. Thank you so much. Yeah, that's what I'm here for. Hello? Yes, yeah, I'm the one that just, what we call, my name is Tom White. Do you have an attorney in this case? Okay. Okay, yeah, then that's me. Just want to make sure you have to do that. So you missed the court because, what date did you miss the court? The 5th of July?
You ready, Mr. White? Courtroom 2 is muted.
Sorry about that, Judge. Yes, we are ready.
All right, we're gonna commence the DV reset case in which Anna Faye Kalina, case 26 CR 001103L, is charged with simple battery family violence. Is Miss Kalina present? She was here.
Well, Judge, I told her to come back into the Zoom. She maybe is in the waiting room. There she is.
All right, Miss Catalina, please turn your camera on. I'm sorry, there we are. We see you. Please unmute. All right, your case today is 26 CR 001103L. You have the absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to counsel today. Are you still here, Miss Catalina? I see you. Please turn the camera back on and unmute. I'm just gonna ask if you understand your rights today. Are you able to unmute very quickly?
There she goes.
Yeah, all right. Do you understand your rights today and how I'm conducting the hearing? All right, you have a right to remain silent. You have a right to an attorney, and I am conducting the hearing by video. This hearing is currently there's a bench warrant pending for your arrest. I'm gonna hear from the state as to whether we should set aside that bench warrant or whether we should require you to surrender yourself to the Fulton County Jail within a certain number of hours. Okay. All right. Do you understand your rights now and how I'm conducting the hearing? Is that a yes? You understand? All right, thank you. All right, Ms. Evans Battle, the state's recommendation.
Your Honor, well, I don't know the basis. Well, state's recommendation would be just based on her not appearing for court on June the 5th of 2026. Notice went out to the 710 Peachtree Street Northeast address with an apartment number that was provided by her previously. That notice was mailed on May the 19th of 2026, and she failed to appear. I will note for that the Rule NYSI also went out to that same location. I don't see in here where there's been a return of
What was it she missed? Plea and arraignment?
plea and arraignment. Yes, so that was June the 5th of 2026. And normally we would not, I don't know the basis in which she missed it, but normally we would allow for the one-time set aside. And we would leave it up to the court at this point once the court hears from her as to reason why she missed court.
Okay. Mr. White?
Judge, she did receive notice at the apartment complex, but apparently it was dropped in somebody else's box at the complex. She didn't receive it until after the date and immediately went down to the clerk's office to have this scheduled. This is a plea and arraignment, so that's the first time she's missed court on the case. We just asked to set aside the bench warrant. I did explain to her that she should, especially now since she kind of burned this one up, not really her fault, but to watch on the website and to call the clerk's office. But the address is correct. Everything, it's just the mail put it in somebody else's mail.
All right, ma'am, I'm gonna set it aside this one time based upon the representations your attorney has made. Again, as he explained, you don't get another one. So if this happens again, you'll be required to surrender yourself. Please be advised that your attorney gave you some information as to how to check on your case. It's my recommendation that you check on it at least every other week, just to make sure you don't miss any other important deadlines, okay? We'll set aside the bench warrant this one time and the case is concluded for today. Is there anything additional?
No.
All right. All right, we'll be in recess until Thursday's SAP calendar. Take care, everyone, and have a wonderful afternoon. Bye-bye.
Bye-bye.